Good evening all. We are here for our next panel discussion, how Consumer Commission interprets automobile cases. And we have with us Mr. Sanjay Pinto, an advocate at Madras High Court, Consumer Commissions, who has won many landmark cases. He is India's longest running legal columnist with 334 columns in Deccan Chronicle till date, an arbitrator, also an author of 4 books and former resident editor of NDTV 24/7. So let's have a big round of applause. So let's start our discussion on how Consumer Commission interprets automobile cases. I believe the entire house would agree that everyone would have had this consumer forum cases probably touching us every now and then. So this is one important topic which could save us from a lot of legal fees, and I believe we should all focus on what Sanjay sir is going to guide us. So sir, our first point is, what principles do Consumer Commission rely on when interpreting disputes in automobile cases?
Good evening, ladies and gentlemen. I quite like that. He calls a lawyer and says how to avoid legal fees. Well, there are 2 ways of interpreting this, Dinesh. From the point of view of a consumer, a customer, and from the point of view of an automobile dealer or manufacturer. You know, there was a disciple who went to a spiritual guru once and asked him, Swamiji, can I smoke when I'm praying? The Swamiji said, what rubbish are you talking? Blasphemy. How could you even think of something like that? So he flipped the question around and said, can I pray when I'm smoking? He said, of course. When you're driving, when you're walking, when you're talking, you can pray whenever you want, whatever you're doing. So you see, the same fact can be interpreted differently depending on which side of the motion you are, which side of the fence you are. Broadly, when it comes to automobile cases, the Consumer Protection Act of 2019 focuses on 5 broad areas. 1, deficiency in service, defect, usually a manufacturing defect, unfair trade practice, unfair agreements, contracts, and misleading advertisements. So these are the broad areas which they look at. And the Consumer Protection Act is loaded in favor of the consumer. Why? Because if you look at the definitions of, for instance, deficiency in service or defect, it says any fault or even imperfection is actionable. Can you imagine? Even imperfection is actionable under the Consumer Protection Act. So if you're an automobile dealer and if you have a case that goes to court by a consumer, the chances are 9 out of 10 that you will lose, unless, of course, you hire me.
That's a good way to...
I'm not, by the way, I'm just a disclaimer here, a caveat. I'm not advertising for myself. I'm not allowed to.
Thank you, sir. The one point which you had said is misleading advertisement. And there are a lot of cases that we get is on the discrepancies between ARAI certified mileage and actual on-road mileage. So can you throw some light?
Last week, in fact, I'm here because of my good friend and my schoolmate Bharat Chodia. We grew up together. So in fact, one case we won recently for Bharat. See, there is a huge gap. There's not just a discrepancy. And there's a lot of misunderstanding in the, come from the point of view of public perception. What is the ideal mileage under ideal driving conditions and the actual on-road driving conditions? When you advertise, you will have a small asterisk like conditions apply. ARAI figures, Automobile Research Association of India, those figures. Now, those figures hinge not on actual road conditions. Those tests, the mileage is actually deciphered from when the vehicle is placed on a dynamometer, when the AC is switched off, at 5th gear speed. So these are the broad factors that determine the ARAI findings. Actual road conditions, traffic. And when you talk of traffic, you know how good it is in Chennai. Traffic, the condition of roads, the quality of fuel, the driving style, and most of us cannot in a city like Chennai drive without AC. So all these factors. Now in the case that we handled recently that we won, I can sue the mobile phone manufacturer. This person had hired call drivers. So when you advertise in a paper, for instance, a newspaper, when you sell a vehicle, you will say doctor driven, single use, single owner. So when call drivers drive the vehicle, there are different driving styles. And this person lived in a remote area in the outskirts of Chennai where the roads were literally the pits. Again, fuel quality. So all these factors came into play there. So I think a suggestion that I make, I think one thing is important. It's important to have people, stakeholders like the government bodies. It's also important for such events to actually have takeaways that you can come up with recommendations. Just like you have ex-showroom price and on-road price. Maybe to dispel the confusion, automobile dealers can think and manufacturers can think of coming up with ARAI mileage and on-road mileage. If you do that, people will then be able to be clear about where they stand when it comes to mileage, because mileage is a subjective thing. Again, mileage does not actually mean the number of kilometers per liter. Mileage, in fact, there's a reference in the ARAI findings to section 115 of the Motor Vehicles Act, which talks about fuel efficiency. Fuel efficiency is not just the number of kilometers it gives you, it also is linked to emission, the pollution levels. So mileage is a broad term, and I think the common customer needs to make that distinction. So my suggestion to Bharat and FADA is to consider, I don't know how feasible it is from a business standpoint, to actually come up with ARAI figures for mileage and on-road figures broadly on an average driving style with 4 people seated in the car with the AC on and on an average road in Chennai, in the cities.
Thank you, sir. And the other pain point that we all dealers get is on service that we do on pickup and drop. So lot of incidents happen and then dealers get into all these consumer forums. So any specific clause or acknowledgements that we should include in our pickup and drop documentation so that we could avoid legal cases?
So again, he's asking me how to avoid legal cases. I'll be committing harakiri there. But anyway, from an academic standpoint here, see, very often when you send a vehicle for pickup for service, and there's a ease of convenience there, everybody likes the vehicle to be picked up and dropped back. So there you sign a form, right? You give them a form. Half the time it's the person, the delivery person, the driver or call driver or whatever who's going to sign that. He scribbles something on a sheet of paper, hardly fills out the details. It's important that you fill out the date, the time, the kilometer at the time of sending the vehicle. But of course, most people make a mention of scratches on the vehicle, any damages, they record all that. But the time and the kilometer is seldom done. That is important because tomorrow if there's some accident that happens, then there's liability. Even for a customer also, it's important to show that I gave my vehicle at this time, at this thing. So what I normally do, the same thing happens when you come. How many of you have come and left it with the valet here? How many of you have left your cars here, the valet? Only one person. All the others have come by bus, is it? Okay.
Quite a few.
Okay. You've got your valet stub with you? Okay. Now what happens, I'm just giving you, I'm sure ITC Grand Chola is a very reliable place, but what happens hypothetically, because this has happened in the past, there are cases also on this. What happens when you go and you give your valet stub and your car doesn't come? Have you thought of it? Your car doesn't come. You've given your only evidence that you have away. Let's say, we don't know. So then pull out CCTV footage. Who has the CCTV footage? The hotel has the CCTV footage. So if the hotel has lost your car, are they going to incriminate themselves? So these are practical realities that we don't think of. So what I normally do, and I'll come back to again the pickup and drop documentation. This is just digressing a bit. Whenever I give my car and I get a valet ticket, I take a photo of that and mail it to myself. So I'm creating a record that at this time, I came here and I mailed it to myself that has the time and the date stamp on it. So in case I come out and if I lose it somewhere, if I drop it somewhere, if the person doesn't think, then I always be able to prove. Because otherwise, there could be a certain problem. What if the person who's driving it out to park somewhere, let's say, forget the hotel, some smaller restaurant, he goes and runs over someone. Ultimately, the police is going to come to your doorstep, right? If it's a hit and run case, you need to be able to prove that you were at this place, at this time, and on this date. So coming back to this, when I've noticed many car dealers, when they send the car back, they ask for feedback. Give me 5 stars, 3 stars, or whatever. They don't give the kilometer reading, and they don't get an acknowledgement from the customer that the car has taken back. That is a serious loophole. I think that's something that needs to be plugged. So make sure, I'm not saying don't trust the customer, but cover your tracks with proper documentation, proper signatures, date, time, kilometer. If possible, the mobile number of the driver who's picking it up as well. So something and in his own handwriting.
Yeah, I think we would request all our dealers to take a note that we should all note down the kilometer, date, time. Probably we could avoid cases.
Avoid legal cases.
See, end of the
We have
day.
a one-point agenda.
See, the entire dealer fraternity here is
I know.
to reduce their legal compliances in a way that we don't get into all these consumer commissions. Sir, your thought on transfer of ownership, because a lot of cases we get is related to transfer of ownership. So your thought on that?
See, I've been lobbying for a long time, writing about this in my columns as well. When you buy a new car, and this is very important for dealers, when you buy a new car, you obviously have to get rid of your old car because nobody really has that kind of space in your apartment buildings or wherever to keep an extra car or 2 cars or 3 cars. So you have to get rid of your old car. If you go to a person like Bharat, he will very efficiently take care of everything and ensure that you have no problems. But by and large, people are unaware of the fact that under Section 50 of the Motor Vehicles Act, the onus of transfer of ownership is on the seller, not on the buyer. So imagine a scenario, and this has happened also in some criminal cases. Suddenly you get a knock at the door, and your vehicle has been used for some terrorist activity, for instance. This has happened actually in the past. Okay? And then you're not able to prove, because the onus is on you. So under Section 50, most of us sign some forms and give it to him. Very often they don't even register the transfer in the RTO records because one more extra ownership, they will try and save money and get a higher value on the resale of that vehicle. That's what happens. So you're very happy with getting a delivery note. I've given the vehicle to you at this. But in the RTO records, your name will continue to exist as the owner of that vehicle. Unless you change that. In fact, I have suggested to the transport department that they should have some mechanism. Within 15 days, if that ownership is not reflecting, change of ownership is not reflecting, you should be able to send a mail to the RTO and they should at least say ownership change or transfer under progress. So you have some legal cover in that. That is something that you need to lobby with the government, tell Mr. T.R.B. Raja to tell his transport counterpart to change this. Section 50 of the Motor Vehicles Act has to be changed because it's a serious loophole there. And a lot of people can get into trouble because of that. Innocent people who sell their vehicles, because the other person does not want to transfer it, will get into trouble. Transfer of ownership, the onus is on the seller, not on the buyer.
We'll surely take note of it, sir, and we'll...
Tamil Nadu government has also introduced it. So when you sell the car, a seller can raise Form 29A.
Yes, but the point is they have to go and submit that, Bharat, in the RTO.
It is online, OTP link, subject to your mobile number is updated in Vahan.
What if you don't submit it online?
If you don't, no, listen to me. 129A, once you submit it, that means you have sold the vehicle to an authorized reseller who is registered under Vahan. So the ownership is transferred from the customer's name to this dealer in Vahan, not on the RC. He will give an acknowledgement on 29B. Again, OTP linked Vahan.
Interim owner.
Interim transfer of ownership. Then the dealer, authorized dealer, sells it to another dealer. He will again give Form 29A. The other dealer will give Form 29B. This can continue till the last Form 30 happens where the original document is transferred.
Okay.
This system has just been introduced.
Okay.
We tried to use it. 29A is working, 29B is working, 29C is not working in Tamil Nadu.
Okay.
So I think
That's interesting. That's a very good piece
Yeah,
of
so
information.
and it is no fees, 0 cost. It can be done online.
Just a show, I want to know how many people are aware of this Form 29A. Show how many people are aware, how many are not aware, put up your hands.
So I think
Okay, so
good
I think
point.
That's a very
30
good,
dealers in Tamil Nadu are registered under the scheme. I have the details of who are registered and all are Maruti dealers only.
Excellent, okay. That's good. I mean, I think some good points are emerging from this, yes.
Thank you, Bharat sir. And one more issue that we all face is because of some our employees' mistake, there has been repeated servicing of same vehicle, and what are the adverse inference of repeated servicing, sir?
See, what happens is there is this, what I call the curse of returns because of e-commerce sites. If you don't like something, return it in 15 days. Now, a lot of people, because of that culture of return, they buy a car, and then they think that if they don't like it after 10, 15 days, so they conjure up some reason and they return it to the dealer. And even if they send it for servicing, some initial issues they have, they refuse to take it back. Despite a clear clause in the agreement saying demurrage charges will apply, 500 rupees a day or whatever. So there are cases, I've had cases where cars have remained for 5, 10 years in the deal, and space is precious, right? The space is scarce. How many cars can you keep as demurrage? The 500 rupees is nothing compared to the space that it occupies. And then the car will not be roadworthy till the issue is actually adjudicated by the commission. The commission can go from the district commission to the state commission to the national commission to the Supreme Court, can go up to even 15 years. The car will not be roadworthy. Who will pay for the insurance? Do you pay for insurance or not? I've dealt with similar cases. So I think it's important that, when you send a car for servicing, if it's repeatedly going for the same reason, for instance, brake failure, and if it's repeatedly serviced for the same thing before the next service is due, then there's a negative inference drawn by the commission that there is deficiency in service in terms of how you've serviced the vehicle. Sometimes it can even point to a manufacturing defect. Also, although the NCDRC has ruled otherwise, saying that how many minutes do we have? We have to get out of the place soon, yeah. So therefore, there's a negative inference drawn when you repeatedly send a vehicle for servicing.
Thank you, Sanjay sir. I think because of time constraint, would like to conclude understanding how Consumer Commission interpret automobile cases helps us manage the risk and ensure fair dealing. So thank you.
One important thing that we left out, if you can give us 2 more minutes, considering we started late. See, manufacturing defect, I think that's the crux really, manufacturing defect. Expert opinion. Understand that consumer commissions, it is a summary trial. It's not like a criminal trial where you stand in the box and give evidence, cross-examined. It's based on documents. Commission members are not experts. They are not automobile experts. So therefore, it's important for a customer when they allege a manufacturing defect, and not all defects are inherently manufacturing defects, that you give an expert opinion. Similarly, for dealers, okay, since you have the connections and the contacts, if somebody alleges a manufacturing defect in the complaint and the car is lying in your workshop and you're charging demurrage, please try and get an expert opinion. Now, it's a different matter that they say that the person who pays the piper calls a tune. It will be doctored or whatever they may, but at least you have something to go by. You can tell the commission, look, this is what an independent expert feels. There is no manufacturing defect. What has happened, there's a lack of awareness. Now, for instance, a lot of car manufacturers, Volkswagen did that some time back about air emissions and all that. There's something called a recall of a vehicle. In common parlance, you understand it, but the common customer doesn't. Common customer thinks recall means there's a problem with the vehicle, the whole vehicle is being recalled and they're giving you another vehicle. Recall is a proactive measure where only certain parts, because of R&D later that has thrown up certain findings, that certain parts are replaced and sent back to the customer. Recall is not replacement of the vehicle. But a lot of consumer commissions are under the impression that recall means, look, there's a problem with this vehicle, they recalled it, they gave it back, so therefore there's a problem with this thing, this complaint must be true. So there's a lot of confusion because of this recall of vehicles.
Thank you, sir. I'm really short of time, but it was...
Sir, sir, can the customer sue a dealer for charging handling charges?
What charges, sorry?
Handling charges.
How will you not handle a vehicle? You have to handle the vehicle, right? Unless it's a robotic vehicle.
No, for which
no, I don't understand. What, handling as in what, sir? What handling?
The company fixes a price. So over and above, we charge, say for example, in a two-wheeler, 1,000 rupees, for which the customer goes for the case.
No, under what head do you charge that?
PDA and handling charges.
There is you're skating on thin ice there, because that could be an unfair trade practice. It could be viewed as an unfair trade practice. Okay. As in over and above. If it's over and above the maximum retail price, then you're walking on eggshells there. Yes. There's a risk there. You'll have to come to a lawyer then.
I think there's an important question for... Give me 2 minutes.
You'll have to ask the lady there, because we are running out of time.
No, just 1 minute. I won't take much. So this question has been asked in every forum, in every conference, right? The handling charges has been legally validated by the Supreme Court, right? We are not taking it for any purpose apart from logistics PDI, right?
No, what do you call it, sir? How is it, under what head? It's called handling, is it?
Yeah, handling charges, right?
Okay.
The point is, I can't discuss in the open forum. There's a Supreme Court decision validated. We can share as a FADA office to you. Please share it to your team members. The answers are there. Thank you.
Thank you, Sanjay sir, for your insightful thoughts. I think we'll close this session here. Thank you, sir.
Thank you.